your relationship with your patients creates certain legal obligations, which for each of those can land both you and the trust in hot water. And over the course of the next hour, I want to go through some of those obligations with you. And I'm afraid increasingly doctors and midwives are involved in spending time with lawyers. I am often met with quite a significant amount of distress, because it is a stressful experience. And those that I do meet, I don't take offence, usually say it was very nice to see me, but they hope they never see me again. So just first of all, a few details about my qualifications to speak to you today. I qualified as a solicitor in 1989. I became a partner at Hempson's in 2002, and our practice specialises in advising the NHS in all kinds of areas of law. But the relevance today is that we are on the NHSLA panel, and we represent trusts throughout the country in defending clinical negligence claims. And my particular specialism is defending birth injury cases. So the plan over the next hour is that I'm going to present to you an introduction to the claims process. And for those of you who've not been involved in a clinical negligence claim, as I say, it can be quite daunting and often difficult to understand why it takes so long and why the processes are so drawn out. I'll take questions either as we go along or towards the end. And Dr. Russell's presentation on a particular case to give us really food for thought. And then I want to come back and just talk to you about the very thorny subject of consent. So I hope you find it useful. So claims, this is a whistle-stop tour of the claims process and the legal procedures. If you're working for the NHS, working within an NHS hospital, then the trust is vicariously liable for your action. And any claim that's brought, the defendant will be the trust. But you will be an important part in that process as a witness to what happened. Obviously, if you're acting in a private capacity, then you're not covered by the trust, and you would need your own insurance. Broadly speaking, there are two types of claim, but there is a common theme that runs through both of them, and that really is that the patient perceives the outcome to be unexpected or adverse. And a common theme that comes through both claims and consent is really managing a patient's expectations. And I've worked on both the claimant and the defendant side of the legal process. And I can speak from experience in meeting with claimants that quite often they really don't know what's happened. And some of them, I think a lot are driven by compensation, but some are driven by a need for an explanation. So the first type of claim is where the actual care is said to have been negligent. And I'll spend some time going through with you just what negligent means. But in terms of anaesthesia, failure to properly test the epidural, insufficient anaesthesia, total spinal nerve damage, and I'll look at some particular cases at the end. The second type of claim that we see is a failure to properly inform the patient about the risk, and then that subsequently materialises, and these are called the consent claims. And they're not mutually exclusive. You can have a case that involves both patients saying they weren't properly informed and alleging that the treatment provided was negligent. So the claims process itself, we may have had an inkling that there's going to be a claim because there may have been a serious untoward incident, or we know something went wrong, we've investigated it, and as a consequence we've concluded in the trust that not all was well, and we're sort of waiting really for that claim to come in. But sometimes the first inkling we'll get that there is a claim is a request by the claimant's solicitors for the medical records. So what the claimant will do, what the patient does, is goes along to see a solicitor, may see an advert or whatever that causes them to go and seek legal advice. And the first thing they've got to do is secure funding. And I think you've probably seen through the press, the whole funding of claims is under review. How that will impact on the number of claims that are brought in the future, we'll have to wait and see. But at the moment, claims can be funded by the conditional fee agreement, the sort of no-win, no-fee. Legal expense insurance, so people may have household cover, and that will cover their bills, or through the public funding, Legal Services Commission. But public funding is a much reducing factor. So the claimant's solicitor writes to the trust and asks to see the records, and at that stage may not provide anything other than the barest information. We've no idea what the claim's going to involve. Once the claimant's solicitor gets the records, they'll then instruct an expert to review the records. And quite often they may go thinking that there is one area of negligence for the expert to say, well, no, actually that was okay, but crikey, have you seen this area? And the claim can turn and twist as it matures. At that stage, once we know that they've sought the records, the trust will undertake an investigation, or the NHSLA will. And the NHSLA is the litigation authority who basically manage clinical risk and the risk pooling scheme into which the trust contributes, and they ultimately will be paying the damages. And they actually are the organisation that would instruct myself at an appropriate point. So once the claimant's solicitors have got their expert report, they will send what's called a letter of claim, and they're required to do that before they can start court proceedings. And this really is an opportunity for the trust to then send a letter of response to say either yes, we agree, or no, we don't agree, and why. And there's 4 months within which to do that. As I say, solicitors can be instructed at any stage in this. As soon as there is a request for medical records in the larger cerebral palsy cases, often I'm instructed to become involved because it's potentially going to involve quite a significant amount of damages. Alternatively, they may wait until they get the letter of claim and then ask for us to be instructed at that stage, or even later, once legal proceedings have been served. And you, as the clinicians, may be asked for your input at any point in this process. From my perspective, the sooner the better, whilst things are fresh in your own mind. Factual evidence is important, and come on to the exchange of that in a moment. But I always prefer to meet with clinicians wherever I can to talk through a case, because when you're trying to work out what's happened, just looking at the bare medical records is often only one-dimensional. You don't get the total picture. I had a Claudia Equina case a couple of years ago where obviously urinary retention symptoms were key to defining the point at which we could and should have acted. And somebody had written a note about urinary retention, and the note above it was typed at 1 in the morning. So everybody was proceeding on the basis that urinary retention occurred at 1 o'clock in the morning. But I noticed that the handwriting was different, and I noticed that handwriting was still carrying on with entries in the notes, that person, at 10 o'clock the following morning, and at 12 o'clock, and I thought, well, I know doctors and nurses work incredibly long hours, but this did seem a long time to have been on duty. And actually, when I met with that person, it transpired that they'd not timed their entry, and in fact, they didn't start on duty until 8:30. So urinary retention couldn't have happened until at least 8:30 in the morning, and that gave us quite good grounds to start arguing about the case. So be prepared, you may be asked for comment at any particular point. Once we've served our letter of response, the claimant solicitors will go away, think about what we've said, and if they don't like what we've said, disagree with our defence, then legal proceedings will be started. And defence will be filed by us, and there'll then be, as I say, an exchange of witness statements, and that's quite an important point for you as the clinicians, when we will need to accurately reflect in a witness statement what potentially you might say if you were ever to give evidence under oath. As the defence, we would also have obtained expert evidence. And here it's important that we get the right experts. Quite often I see A&E cases where the claimant solicitors have gone off and got a professor in neurology to comment upon what a junior A&E doctor said. You have to have the right discipline, you have to have the right hospital background, and you need to check the last time they were actually ever in theatre or practicing, because some experts become professional experts. So we get the expert evidence on behalf of the trust, and we then exchange that with the claimants, and we see what their experts saying about the conduct of the case, and they can see why our expert is saying that we did nothing wrong. Quantification of the case, I will come back to that a little bit later. That can either be happening as the case progresses through these stages, or it can happen separately. Sometimes the courts say, well, let's just resolve whether you're liable for the case or not before we raise expectations with reports that on quantification. Usually, though, it is held together and we start looking at how much the case is worth. The next stage, once we've swapped our expert reports, will be for the experts to meet and discuss the case. And this is a relatively new step that was introduced with the Lord Wolf's reforms. And it is, in my opinion, quite helpful if the experts enter into the discussions in the right frame of mind. And sometimes the experts, when they meet to discuss the case, may agree that, you know, they'll see each other's side of the argument. Sometimes at that stage the case may disappear, and the claimant's expert may say, yes, I haven't appreciated that particular factor. And similarly, our expert sometimes comes back and says, I'm really sorry, but from what they've told me, I can see what they're now saying, and yes, I do agree. It'd be far better to know that now than in a courtroom. But quite often the experts agree simply to disagree. And then we find ourselves in trial. Now, trial is a very rare occurrence. In my years at Henson's, I've taken 4 cases to a liability trial. We've won them all because we only take those that we are confident will win. Because of the vagaries of the judicial system, trial is not always the best means of resolving a case. The timescales can be very long, and I think that's what surprises a lot of clinicians that I meet, just how long these cases can take. And just to pause briefly and talk about the limitation period. A claimant has got 3 years from the date of negligence within which to start court proceedings. That's the basic rule. But that often isn't the time frame that they're held to. If they don't have any knowledge about the negligence, then time doesn't start to run until they gain that knowledge. So if it's been a silent injury that manifests itself years down the line, they will argue their date of knowledge was actually, years down the line. For children, it doesn't start until they reach the age of 18, so they have got until they're 21 to bring a case. And for anybody with no capacity, who doesn't have capacity, so for example the cases I deal with cerebral palsy, there is no time limit. So I've got cases where children were born in 1960 and we're still going through an investigation procedure. So time limits can be incredibly long. Once they do get into court proceedings, then the court will manage the timetable. They do tend to pick up and move along a bit faster these days. So at any stage, a party can make an offer to settle, and what we will be doing as the case progresses, as we get the evidence in, as we get the statements in, as we get the expert evidence in, we are constantly assessing the strength of the case and whether it's one that we can defend or whether it's one that we should be looking to settle. So just coming back to the principles, tort of negligence, and I said there are two types of claim. One is where the standard of treatment fell below the standard that could be expected. And the area of law that we're working in is the tort of negligence. And for a claim to succeed, it's not enough for the claimant to say, I just don't like what happened, wasn't the outcome that I wanted. They've got to demonstrate these three principles. Firstly, that there was a duty of care owed. Secondly, that that duty was breached. And third, that the breach caused some recognisable harm. And the claim can fail at any of those stages. They're all interlinked. They have to have, in a sense, I always think of it like a train with carriages attached. They all have to be linked. So duty of care, that's usually pretty straightforward in the cases we work with. It's a legal obligation, impersonal and individual, requiring that they adhere to a standard of reasonable care while performing any acts that could foreseeably harm others. Now, for lawyers, they get very excited about that phrase because it's got all kinds of legal arguments in there, foreseeability, but generally for doctors, you owe a duty of care to your patient. There are constant attempts to push those boundaries, and as a practice, we had a case went to the House of Lords a few years ago where parents and children were trying to say we owed a duty to the parent where we were treating the child and where we'd raised issues of abuse, and those allegations actually turned out to be false, and the parents said, well, that's caused us recognisable harm, but the court said no, in those circumstances our duty was to the child, or the doctor's duty was to the child, not to the doctor, so not to the parents. So they are constantly trying to push the boundaries. So what is the test, and what does standard of care mean? It was set out in a case called Bolam, and a doctor is not guilty of negligence if he has acted in accordance with a practice accepted as proper by a responsible body of medical men skilled in that particular art. Or putting it another way, a doctor is not negligent if he acts in accordance with such a practice merely because there is a body of opinion that takes the contrary view. And one of the cases I took to trial was an orthopaedic case where we were being sued for not undertaking a derotational osteotomy, and our expert said perfectly reasonable not to have done that, and the claimant's expert was saying we should. And under cross-examination, when he was asked this question, is there a body of orthopaedic surgeons who would not have offered a derotational osteotomy, he said, oh yes, I suppose there is. At which point the judge put his pen down and the claim ended. That was before meetings of experts, by the way, you shouldn't have done that. So only negligent if no responsible body of medical opinion would consider what was done to be reasonable. And I think the important aspect of this slide is the middle point, that we've got to apply the standard of care at the time the breach occurred. And we must not look through 1954 spectacles to what happened in 1947. It's quite an old case. So coming back to my cerebral palsy case that's going back to the 1960s, incredibly hard case, because we've got to try and remember what the practice was in the 1960s, and it has changed substantially. And I've also got to try and find an expert who was a consultant in the 1960s and still compos mentis to give evidence. Even harder. So that's the test, really, is whether a responsible body would consider your practice to be reasonable. And that used to be the end of it, but there's a bit of a twist now, and it's called the Belitho test, and it's not just enough to wheel out an expert as your body of responsible opinion, because the judges have said that that responsible opinion has got to stand up to logical analysis, and there's got to be a question of the comparative risks and benefits. So it means, essentially, that irresponsible medical practice is determined, so the test at the end of the day is the court's decision, not the experts, and the court can say, I don't, I listen to what you've said, Mr. Expert, but what you're telling me just doesn't stand up to logical analysis, and I don't accept it. Okay, so having established that there's been a breach of duty, that doesn't get the claimant home. They don't win the case just because we've done something wrong. They've got to go on to prove that what we did wrong has actually caused some harm. And in clinical negligence cases, causation is the most complex part of the investigation. The test is there, it's called the but-for test. But for the alleged breach, would the damage have occurred? And the reason it's complicated in clinical negligence is because, by its very nature, most of the patients have got an underlying condition, and it's extracting out of that scenario just what additional harm has been caused, and that's where the lawyers and the doctors part company, because we're insisting on black and white, and usually the answers we get are somewhere in the grey region, and that's the most difficult part. And the question of causation can be twofold, and sometimes this gets a bit fudged and not to be fudged, because there is a factual causation question to ask, and that is, for example, in the case of Belitho, where the negligence was not calling a senior clinician. The first question to be determined is what would have happened if that clinician had been called. And then, once you determine that factual question, how different would the outcome have been? And it arises all the time, that twofold approach to causation. I've got a case running with a subdural hematoma, and the question is, what would have happened if we'd have scanned? What would the scan have shown? And then the next question is, what treatment would have been given? And then we come on to the medical question of how would that treatment have altered the course for that particular patient. So they are very difficult. The test is on the balance of probabilities, so more than 50% likely that this would have happened as opposed to that is the test that's applied. And you can have a standalone defence on causation even if breach is admitted or proved. So the last two cerebral palsy cases that I took to trial, we had to concede that one of them we conceded that the baby would have been born sooner, but it was the baby's damage was caused by a neonatal stroke, and we defended that case on causation on the grounds that the stroke was not caused by the delay in delivery. And we succeeded. I think for claimants that's the hardest part, to know that something's gone wrong but it's not actually provable in damages. And then finally, if they can prove the breach of duty and they can prove it's caused some form of harm, the next question is how much is the case worth? And here we've got to get experts to separate out what part of the claimant's condition is due to the breach and what part of it is due to the underlying condition. And here is how the damages are calculated. The first part is general damages for pain and suffering. And if I tell you the maximum award for pain and suffering in the maximum brain injury case is £265,000, and then you see the multi-million-pound awards for cerebral palsy, the balance of the damages are made up by what's called the special damages, and they are awards for care, loss of earnings, therapies, accommodation. So the actual pain and suffering component is usually comparably relatively low, and that's really been capped by the courts in this country, because we don't have a jury system for assessing damages. So the outcome for any case that starts can be a variety of outcomes. It could be a discontinuation, so the claimant could go get their expert report, and the expert could say, no, there's nothing wrong here, or they could discontinue at any point once we've swapped expert evidence. Alternatively, on the trust part, there could be an admission and a settlement on a full liability basis where our investigations show that there was a breach and it caused the harm. Or there can be a settlement without any admission, so the trust are not accepting liability in that sense, but there is a negotiated compromise to reflect the litigation risk that if we had to go to trial, we could lose the case. And that could be anything from, it would never be naught because that would be a discontinuance, but it can be from a relatively low percentage up to the full value of the case. Or we can take our chance and go to trial. And costs do what's called follow the event in this country. So if you win your case, you are awarded your costs, and costs are an increasing component of the settlement of any case these days, and that is what the government's trying to address by looking at conditional fee agreements. And I've just included a few slides on the kind of negligence cases that come through anaesthesia, difficulties with tracheal intubation. Here we see soft tissue damage, damage to teeth. I was surprised to read that 52% of anaesthesia cases that are referred to the MDU involve damage to teeth. Failure to achieve intubation or to follow the intubation drill. Misplacement of the endotracheal tube, inadvertent enterobronchial intubation. Nerve injuries, spinal and epidural blocks, awareness during anaesthesia, I've just heard of an example of that. And brain damage, usually most of these are equipment failings that I've listed below. So that is the life of a whistle-stop tour of a claim. I don't know if anybody has any questions or if you want to do those at the end.